Hey, what's up? Hey,
Morning, Your
hi, how
Honor.
are you?
I'm here on Miss Belén Ibarra.
The last
Ibarra.
Ibarra. Okay. What's the word?
So, this first for bond, she has no bond set in this case because she was on no bond for the felonies last time we were here. But the state is unopposed to a PR bond in this case because
She's being held at no bond on the upstairs.
I know, and
So-
the felony attorney is working on that. They resolved the felonies on Friday. And
They
the
resolved-
bond was not relitigated up there.
She's
I'm
going
just
into
on
a
the
PTI. She's going into like a 1-year PTI upstairs. And as part of that deal, we're gonna get rid of our misdemeanor, but obviously she needs to get out in order to get into the PTI and everything.
The felony attorney knows about the bond issue. I don't know when she plans to address it, but I'm just here to get her out on the misdemeanor.
Since it's gonna be dismissed one way or the other with the felony PTI. So I just want to make sure that, our case isn't, holding up the felony offer essentially.
Is she here now? Do we
Yeah,
have
she's
her?
in the holding cell.
Do you mind bringing her out? I mean, they don't even have a date set upstairs though. It's
That's
set for
I know, and
126.
I've spoken to the felony attorney. It was a misstep on her part for sure, but I spoke to the felony attorney and she will go approach on it at some point. I mean,
Are you anticipating a PR bond upstairs too?
I would assume so, yes, because she has a PTI, like the felonies have been resolved, so I would assume
Never
yes.
assume anything,
I
you
know,
know?
I know, and I can't speak for what happens in the felonies. I'm only on the misdemeanor, Your Honor, but
And I just see that the agreement's is in deeds and everything, so.
Yeah.
It looks like we're moving towards that.
yeah.
I just want to make sure that we
When
don't,
do you want to set it for? Do maybe like a week
Yeah, that's fine.
and we'll see. Okay.
That's fine.
Does she have history of like flight? Do you know? Because she's got
She
two.
has no history of flight. She lived in Houston most of her life. She is pregnant right now. She's 6 months pregnant, and essentially, we just kind of want to.
She has
get her
two
out.
prior assault cases. Both of those, any flight in respect to those cases?
I'm not, I actually ran over here.
I don't think, so. Based on what district clerk shows, no, Your Honor.
Let's take a look. I don't see.
All right, go ahead and sign.
So she only has one prior assault. It looks like that one was dismissed. And
Yeah.
this new one here, looks like it was charged assault of a hospital personnel, right?
Yeah, that got dismissed on Friday.
Did they refile it as? Okay.
It just got plain dismissed, and then the PTI is for the assault on a public servant, I think. It's a mental health case.
This is a quiet but huge moment. A PR bond means no money up front. The court is trusting her word. That trust doesn't come easy, especially with prior assaults on the record. Notice the judge's tone. Fair, but already laying the groundwork. One mistake, and this door slams shut fast.
CW.
CW,
Hold on a second. We'll get there.
yeah.
Colin,
Mr.
tell me, what you got?
I have Sarah Castillo, Judge.
Okay.
That's the one where we were trying to get the records from the sheriff's office. They finally got them to me. And
You have everything you want?
I haven't been able to get through it all. It's like almost 600 pages.
Second. I didn't thought it was gonna be long. Okay. Gabe. Blossom. Do you speak English, ma'am?
Yes, sir. Yes, Your Honor.
You see, Bar, I want you to understand and appreciate that you have a lot of lawyers that are going to bat for you now, trying to help you even get out. Your lawyer here is asking for a PR bond. You even have the state that's in agreement to get you a PR bond. The only thing that we're asking you to do is be safe to our community. Don't pick up any new cases and stay in contact with your lawyer. Right now, I'm going to grant you a PR bond, but I'm not going to do this over and over and over and over and over. I'm going to give you one chance to get out there and do the right thing, make the best of the chance that you're giving. But if you get out there and you just take off and you don't stay in contact with anyone and you pick up a new case, all bets off. Do you understand?
Yes, Your Honor.
I'm not asking for much. All I want is my community to be safe and for you to stay in contact with counsel. That's it.
Judges don't repeat themselves like this unless they're drawing a line in the sand. This is an encouragement. It's a warning wrapped in mercy. The court is saying, you get one shot, blow it, and it's cuffs next time. And everyone in that courtroom knows it.
Who's the complaining witness?
Dating relationship, boyfriend.
Okay. Does he want to have contact with her?
He's not, we haven't really been, he hasn't been cooperative with us, so I wouldn't be able to tell you what he wants other than to drop charges, really.
So I want you to understand that I am going to grant what's called a magistrate's order for emergency protection that identifies Mr. Rodriguez as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072, which is the stalking statute. You cannot threaten, harass, use another person to communicate threat or harassing behavior, and you cannot be in possession of a weapon. Do you understand?
Yes, Your Honor.
I'll take off the residential restriction just in case, but everything in the MOAP is stuff she shouldn't do anyways. All right, understand.
Yes, Your Honor. Thanks.
Judge, I just had a quick question. We're set for trial tomorrow in ERD on a family violence case. And I just wanted to know logistics wise, would we pick tomorrow and then start Wednesday? Or if we have a jury tomorrow, do
Are
we
you
just?
really gonna go?
I mean, it sounds like we're gonna go.
You hear this?
Yes, Your Honor.
I've got 7 other cases set for trial as well tomorrow in here.
Okay.
So let's see which one actually
Yeah, let's see
goes.
what the trial-
So, but technically we pick on a Tuesday, everything starts testimony on a Wednesday, and then we go. That's the way. So, yes, thank you. Mr. Arsenault, you are charged with interference with the emergency request for assistance. You are facing up to a year in jail and or a $4,000 fine. It seems that probable cause has already been found in this case.
Yes, sir, Judge. I don't know why we're here, but,
Because he bonded out.
Oh, yes,
He's
sir.
been, I guess he's been AWOL, right?
no, sir, he's been in custody, Judge. He had a felony, assault of a family member that was dismissed last week,
Okay,
and that's why he got out.
all right. So are there any kind of bond conditions that you guys would like state?
So for this one, just standard conditions would be fine with this type of case. And there's no contact for this,
Who's the complaining witness in the,
His mother.
his mother, judge.
okay. Is that the complaining witness that was in the felony as well?
That's correct, Your Honor.
Okay, so I'm ordering you not to have contact with this person. Do you understand?
Judge, if I may, I provided the state with some information relative to that. The complaining witness in this case is not willing to go forward. She's provided a letter to me, which I have already given to the state. She's requesting that the case be dismissed.
The state would not be opposed to no threatening or harassing contact at this time. And just give us another date to reset to look at the 911 phone calls to make sure that.
Okay, so the case is 180 days old. It's time. So I'll give you a
Okay.
week.
Yes, Judge.
So I'm ordering you not to have any threatening or harassing contact with the complaining witness in this case and not to be in possession of weapons. If I find that you violate these conditions, I'm going to revoke your bond, put you in jail. Do you understand? I'm not asking for much. Now, your case is old. It's time to figure out what we're going to do. So I'm going to give the state a week to get everything done, wrapped up. They're going to put an offer on the case. The next time we come back, you must either accept the offer or I'm going to set your case for trial. Do you understand?
Yes, sir.
Okay. So do you mind filing those conditions, please?
Yes, Judge.
All right. We're going to have you sign the conditions. After that, we'll see you in a week. We'll go from
Thank
there.
you, Your Honor.
Okay. Thank you, Mr. D.
Yes, sir.
You are not allowed to drive. Do you understand? If I find that you pick up a new case or another third case, I'm going to go nuts on all of the bonds. I'm also going to test you 45 to 50 days from today. You're not to use marijuana at all. Do you understand? If I find that the next time I test you and you test positive, it's just not going to go well for you. You understand? We've given you a lawyer. There's just no more excuse. If you get your license and insurance, Mr. Jackson, I will happily take this restriction off. All I'm asking you to do is follow the law. I'm not asking you to split the atom here. Really?
And Judge, we're working on it. We have a out of state fine or suspension, but we cannot figure out what state it comes from at the moment. So we are
Call
working.
DPS, you know.
Yeah. Because they're even
You
when they
can
run.
call DPS. Have I given you the phone number?
This is pressure, courtroom style. The judge is forcing the clock to move. No more delays, no more resets, no more limbo. Take the deal or roll the dice with a jury. And trust me, that's not a gamble most defendants want to make.
Never get through. Right when the phone line's open, call them. All you have to do is ask them, what do I need to do to be able to get my license? And then they'll tell you. All right, I'm gonna have you come up here, promise to us that you're not gonna drive, then I'll get you to Victoria, sign a reset. You'll get with Felicia for your bond conditions, and after that, you're ready to go. All right, good luck, guys. You got it. Ms. Johnson, you're charged with making a false report to a police officer. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 19th, 2025, at approximately 1:56 p.m., the officer was dispatched to a child custody dispute at a residence in Harris County, Texas. The officer made contact with the defendant's husband, who requested a report be completed because the defendant did not meet him at a scheduled time and location. The officer made contact with the defendant at 4:45 p.m. via the phone, and the defendant was advised about the husband's request for a report. The defendant became upset and stated she was going to call the defendant's probation officer and say what she needed to say to get his probation revoked and serve 2 to 10 years in prison. The defendant stated she had video footage of the husband assaulting her last month on the phone, and she was going to call and have a deputy come to the residence to pursue charges because he completed the report. At approximately 5:37 p.m., the defendant made a family assault call, and the call slip stated, "See reportee," in reference to the husband cussing and pushed the reportee. The officer, who had previously contacted the defendant, arrived at the family assault call at approximately 6:02 p.m. and made contact with the defendant. The defendant stated the husband pushed her on 2 separate occasions in January 2025, and the defendant then stated the husband did not punch or push her, he merely brushed against her and admitted it was not intentional. The officer asked to see the video the defendant stated she had. The defendant denied making that statement, and the defendant then admitted to making the statement and stated she did not have a video, but the daughter was present. The defendant stated she did not feel pain, did not have visible injuries, and wanted to pursue charges. The defendant then attempted to change statements again, stating she never made a call for service. The officer read the call slip, and the defendant stated dispatch did not hear her correctly, and that was not what she meant to say. The defendant further denied making a statement regarding the husband's probation. The officer replayed a body-worn camera video of the defendant's statement while on the phone, and the defendant admitted she was not telling the truth.
I never noticed it.
All right, ma'am, I'm gonna find if there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand? That is the gentleman in this case. If I find that you have contact with this person, I'm going to revoke your bond. Look, I can provide you a lawyer today. You can explain your side to the lawyer, but I've got a bunch of DAs here. Anything you say, they're going to try to use it against you to prove guilt. Just don't. I will give you a lawyer. Just explain your side to the lawyer, and then they can go talk to the DAs on your behalf. But I don't want you to say something where you put your proverbial foot in your mouth, you know? Don't. Just. So what I'm going to do is I'm going to have you sign a receipt with Victoria. I will have you then take a seat in the jury box. I'm going to find you a lawyer, and then you can explain your side to the lawyer. Okay? Let me see one thing real quick. I need you to fill an application for me, though. Do you mind? She's going to give you an application. I need you to fill it out, and then I'll have you talk to someone here momentarily. No. Ms. Prejean, you are charged with aggregate theft. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. The officer met with the complainant, the Walmart Asset Protection employee, and the complainant stated that he reviewed store surveillance. And on September 12th, 2023, the complainant observed the defendant open the register multiple times, take cash, and place the cash into pocket, a total of $790.41. On September 13th, 2023, the officer observed the defendant conduct a fraudulent return for a total of $60.02. And on September 18th, 2023, the complainant observed another fraudulent return by the defendant for a total of $101.77. On September 20, 2023, the complainant observed the defendant process a fraudulent return, take money from the register, and conduct a fraudulent return to obtain a gift card following the transaction for a total of $120.64. The complainant stated the defendant did not have permission to take money and desired prosecution. The officer made contact with the defendant, who admitted to stealing from the business 4 times, with each time being $200.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go to any Walmart for any reason. Do you understand? If I find that you go to Walmart, then I'm going to revoke your bond. I'm going to put you in jail. Did you need a lawyer, ma'am? Okay, I'll appoint you one today. I'm going to have you sign a receipt, Victoria, then we'll have you take a seat in the jury box while we find your lawyer, ma'am. Ma'am, you were charged with assault. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am.
Yes, Judge. On January 20th, 2025, the officer arrived at the complainant's apartment due to a disturbance call, and the complainant asked the defendant to leave her apartment after a verbal argument. The child was present, and the defendant then pushed the complainant, leading to further argument. The defendant, instead of pointing at the complainant, landed at least one with her right hand, which were also holding a pair of keys. The keys scratched the complainant's face, leaving red marks. The complainant then held the defendant on the floor to stop her from punching her until she calmed down, at which time the defendant proceeded to spit in the complainant's face. The complainant then let the defendant up and told her to leave. The complainant stated her pain level was about a 3 out of 10, and the officer observed the complainant.
And that right there is the case collapsing in real time. Changing stories, no video, contradicted by body cam. That's how a false report charge sticks. This is why judges constantly say, stop talking. Every extra word just tightens the knot.
Probable cause to go forward with your case, and I'm ordering you not to have contact with this person. I'm also ordering you not to be in possession of weapons as well. Did you need a lawyer today? Okay, I will appoint you a lawyer. For now, I'll have you sign a receipt with Victoria. We'll have you take your seat in the jury box. Do not leave until you sign our bond conditions, then I'll have you speak to the lawyer here. Okay, please. Okay, ma'am, you're charged with driving while intoxicated. Second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you.
Yes, Judge. On January 20th, 2025, the officer, a certified DRE, was dispatched to the scene of a wreck at a parking lot in Harris County, Texas. The defendant had been refused entry to a bar at the location due to appearing visibly drunk by the staff. A witness stated the defendant was not walking straight and had a hard time standing. The officer observed the defendant trying to back up from the scene of the wreck when he made a stop. The defendant had watery eyes, a strong odor of alcoholic beverage, and furthermore, the defendant was not making any sense when describing what had transpired to the officers. The defendant was transported to Pasadena jail, where Miranda was read and SFSTs were performed. HGN 6 out of 6. Walk and turn. The defendant took 15 steps instead of 9 and missed every heel to toe. In the one-leg stand, the defendant used arms and swayed. The DIC was read and the defendant consented to breath. The results were .212 and .217.
And Ms. Tovar Martinez, I'm going to find that there's probable cause to go forward with your case. Do you see if she has a valid license, please?
I'll run it right now.
I am now placing a restriction on your license, ma'am. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If I find that you drive a vehicle that doesn't have one, I'm going to revoke your bond, put you in jail. No more PR bonds. I am also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using anything illegal, likewise, you will go to jail. No more PR bonds for you, ma'am.
We have no license on file.
You do not have a license, then no driving. Do you understand? You will be signing an affidavit with me today, promising you're not going to drive, and I don't care what is going on in your life. Do not drive. Since I'm ordering you not to drive, you will get a handheld interlock device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol, man. I'm sending notice to DPS in Austin that every single officer in the state will know that if you get pulled over, you're supposed to have an interlock in your car. So if you're caught driving a vehicle that doesn't have one, they're going to put you in jail. Do you understand? Would you like a lawyer today, ma'am? Okay, so for now, what I'm going to do is I'm going to have you go to Victoria, sign a reset. You will get with Felicia for bond conditions, and then I'll have you take a seat in the jury box while we try to find you a lawyer, man. Okay. Morning, Mr. Daniels. Do you have a lawyer today?
Sorry.
You want to apply for a court-appointed lawyer?
I started working. I'm gonna get, I know I was just a second. Have a lawyer next quarter.
I'm willing to give you a free one.
Okay.
Okay, it's up to you. If you have any problems, come back.
I just started working, so I'm saying,
Good job, man. Great. What are you doing?
delivery, so. Third parties,
Get a trade, dude. Get a trade. Go like welding or something like this.
I got my list. It's hard finding jobs. It's hard, like, so I knew somebody that got me in with the delivery, so.
Good.
Yeah.
You know, the better you do, the higher you're gonna go. Anything in life, man. Put your heart into it. Your sky's the limit. Right. Okay. THA. All right, we got you, man.
Thank you.
Good luck. So, ma'am, it looks like your lawyer was involved in an accident this morning, so he's not going to be here. So what we'll do is we're going to do probable cause. After that, we'll just give you a normal reset. They called us to advise you to call the office, and then you guys can get together with them. Okay. So, ma'am, you're charged with theft. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes.
Okay.
On January 19th, 2025, the officer was dispatched to a target in regard to a theft. The officer made contact with the complainant, a loss prevention employee, who stated she observed the defendant walking inside the store, grab a shopping cart, select numerous items, place the items inside the basket, and conceal cosmetic items, food, and office items inside her purse. The defendant headed to the register where she only paid for the items in her basket before exiting the store and passing all points of sale. The total was $111.28.
All right, Ms. Saldana, I'm going to find that there's probable cause to go forward with the case. Where is this from again?
Target.
Target. I'm ordering you as a condition of your bond. Target. Do you understand? If you violate this condition or if you pick up a new case, a warrant for your arrest will be issued. No more PR bonds, man. So can you file that, please?
Yes, sir.
I'm going to have you sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it, and after that, you'll be free to go. Okay? So Danuna was in an accident this morning, I guess, so he's not going to be here. So we'll just do a regular reset. Just do, I guess, 30, 45 days. And then she needs state's conditions. How are you?
Good, how are you, sir?
Happy Monday.
I'm sorry, I couldn't hear you.
Happy Monday.
Oh, happy Monday.
I have one of our trial cases for tomorrow.
I believe I have one set, but I think he pled his felony.
It's Mendoza.
Yeah, I think he pled his felony, and if not, I will announce not ready, mostly because I got texted some videos last night. Well, I got emailed some videos last night.
Let me pull them up real quick. Hold on.
Well, I got emailed some videos last night. I
let
feel
me
like
pull
he
them up
was
real quick.
dismissal if he pled the felony, and then I think they rushed the felony. I feel like he was dismissal if he pled the felony, and then.
Judge, do you have the case number?
Felony.
I do.
Okay.
2502-101.
Judge, do you have the case number?
And 02. I do.
Okay.
They reset it.
2502-219.
101.
My
Yes.
problem is I have like,
And 02.
they all overlap,
They
and I
reset
swear I
it.
have two reckless
See,
drivings, each of
219.
them with a gun, and one of them calling
Yes.
out to
Yes.
say pled. I guess it might have been the other one. They all
Our gun
overlap, and I
case
swear
pled,
I have two
but the reckless driving
drivings,
is
each
still
of them with a gun, and one of them called my office to say he pled. Okay. I guess
And
it might have been
then-
the other one.
Our gun case pled, it looks like, but the reckless driving is still open. The felony evading in the vehicle
Okay.
got reset to
And then-
219. It looks
All
like
right. I'll,
the felony
Can we hold
evading
off on that till
in the
tomorrow,
vehicle
Judge?
got reset to 219.
because I thought, I came in here
All right.
thinking that he had already, they had pled upstairs. Can we hold off on that till tomorrow? And I obviously got the guy confused, he pled upstairs. I thought, I came in here thinking that had already. Because a client called me to say that he had pled, and I obviously got the guy confused. And I thought it was upstairs.
What are they doing upstairs? Is there any news?
Client
We're
called
in
me
touch with
to say that he
defense
had pled.
upstairs, and they are gonna take,
And I
the
thought it was
defendant
this
is gonna take the deferred and
what are they
felony
doing
and then
upstairs?
dismiss
Is
our
there
cases,
any
adding the
news?
condition
We're in
about
touch with
the
defense
firearm, I
upstairs.
believe.
Yeah,
and
they're
they are
doing a
gonna take-
TRAS? Is that
the
why they
defendant
did the
is gonna take
reset?
the deferred and felony and
Are they
then
doing a
dismiss our
TRAS
cases,
upstairs?
adding
Is that why they did
condition
the reset?
about
Because a lot of
the
times
firearms, I believe.
prior
and
to
they're
a
gonna
plea,
take
they'll
the
do
TRAS.
TRAS. They did the
You
reset.
reset from the last
Are they doing a
setting
TRAS
without
upstairs?
actually
Is that why
agreeing
they
to
did the
plea.
reset? Because a lot of times
Kelsey then sent out
prior
the
to
email,
a
hey,
plea,
will
they'll
you
do
do
the
it?
TRAS.
They agreed to plea. From the last setting my client called me to tell me that he had done the plea. Kelsey then sent out the email. I think he has now agreed.
Did they do the plea and they just set it for this, to do it to you?
They hadn't officially done it yet, sir, but I'm
he's now
talking
agreed.
to
Did they do the
defense,
plea and
felony
they
defense
just set it for
counsel,
this, to
and
do it to you?
we were hoping you could
They
just
hadn't
come do
officially
it
done it yet,
tomorrow
sir,
when
but
this
I'm
one's
talking
set for
to
trial, but we wouldn't
defense,
actually be
felony
going on it
defense
because that was the
counsel,
agreement.
and
We were hoping you could just come do it tomorrow when this one's set for trial, but we wouldn't
Bless you.
actually be
Whoever
going
you
on
are.
it because that was the
in
agreement.
custody.
No, he's on bond.
I'm looking at the, I'm just looking at
I will
the-
say, I got the cell phone video that was emailed to me yesterday, and it's not
I'm
particularly
looking at
reckless.
the,
Yeah,
I'm
yeah,
just
the
looking
donuts,
at
there's a
the-
good distance between him and all the other cars. That was emailed to me yesterday, and it's not particularly reckless. Yeah, yeah, the donuts, there's a good distance between him and all the other cars. Shush.
On the reset, they didn't mark anything, and then under settings, it's just a non-trial setting, so.
So they reset it, and then after they
On the
reset
reset,
it,
they
we,
didn't mark
Kelsey, and I'll
anything,
give
and then
all
under
credit to
settings,
Kelsey,
it's
sent
just
all
a
the
non-trial
emails and got
setting.
everybody to agree to take the plea.
And then
So
after they
all the
reset
paperwork
it,
was before.
Kelsey, and I'll give
Wolf
all
had
credit to
agreed to
Kelsey,
take the
sent all the emails and got
You
everybody
said you want to set it for tomorrow?
So, no, I thought he had already taken it, and I think we're set tomorrow.
Right.
So
You
I
said
can have
you
the
want to go
client
ahead
come in
and
and
set it?
Well, I can walk him up to
I thought he had
felony
already
court,
taken
except for the
it,
fact that
and I
I'm not
think
his
we're
felony
set
lawyer, so I
tomorrow.
can't take the plea.
Right.
So I can have.
I'm not asking you to do that.
No, what I'm saying is
Hey,
I
set it
can normally do
after the
that.
felony.
Oh, yes, please. But I would say leave it for
I'm
tomorrow,
not asking you to do
because
that.
I don't want to
What I'm saying
communicate
is
with the
I
client.
can't
Set
I
it
could normally do
after
that.
the
If he's
felony.
not set tomorrow,
yes,
I might not be able
But
to
I
get
would say
hold of
leave
him.
it for tomorrow.
He might come in anywhere.
Because I don't want to
So
communicate.
if we leave it
Good on
tomorrow,
it.
he comes in, I say
If
hello.
he's not set tomorrow,
And then I set it for the day after the felony.
So what if he doesn't show?
Tomorrow?
So if we leave it
Good on
tomorrow,
it.
he comes in, I say hello.
Up to the beans?
So I
And then I
revoke
set
it?
it for the day after.
I would hope not, but
So
that's
what
a
if he doesn't
conversation
show?
I'll reserve for tomorrow.
Up to the beans.
Once, so I revoke it? Okay.
I would hope not, but that's a conversation you're taking reserve for tomorrow. You're thinking 2 steps ahead, but like kind of in a lateral direction as well.
Have to.
Yeah, I know, but right now we have a resolution. It's 2
plotted
steps
out, but then
ahead,
get this
but like
resolved.
kind of in a lateral direction as well.
I'm choosing to think positive.
I know, but right now.
Also,
we
I'm
have
trying
a
to suck up to
resolution,
this
it's
one because I need a
plotted
time
out,
served
but
offer on a
get this
different
resolved.
case.
I'm choosing to think positive. All right. Thank you, judges. Also, I'm trying to suck up to this one.
Morning,
because I
Mr.
need a time
Harris.
served offer on a different case.
Mr. Harris, you're charged with assault of a family member. You're
Thank you,
facing
Judge.
up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you a 15-month deferred. This is a type of probation that if you successfully complete it, you do not end up with a conviction on your record. What you must understand, though, is there is an affirmative finding of family violence in this case, meaning that you ever pick up another one of these cases, you will be facing a third-degree felony, minimum of 2 years, maximum of 10 years in prison. Do you understand? For you to complete this successfully, you must do a Batters Intervention Prevention Program, a BIP class. This is tough because this class is you must do it once a week for 18 weeks. And if you fail to go 1 week, they're going to kick you out. You get kicked out. We issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out. You're facing up to a year in jail. Do you understand? It's no joke. No alcohol, no drugs. You must do also what's called a TRAS, an evaluation, to see what other conditions you may need. If they assess other conditions, you have to fulfill them as well. Do you understand? Weapons, no. Harassing, threatening, abusive contact with Brittany Senegal and Chanel Clayton. Mr. Harris, I will make you a deal. If you get this done quickly, I will take you off in half the time. If you're nice to everybody, get your classes done quick, sign up as soon as you start getting this thing, I'll take you off in half the time. You can be done in this thing 7.5 to 8 months if you really kick butt. Be nice to everybody and just don't test positive. Do you understand? Like I said, if you violate this thing, I'm going to issue a warrant for your arrest. You're looking at a year in jail. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, you're stuck with this until you complete it or you get revoked. You understand? Shh. How do you plead to the offense? Guilty or not guilty? I will not find you guilty. I will withhold it for 15 months. Do well. Done. 7.5 months. All right, good luck. Defendant. What do you do? What do you do? Say it again.
He's working full time.
Okay, what do you do for a living?
Deliver fine.
Okay, how many kids you got?
So
Okay. Reduce the fees. Yeah, I'm trying to find out, so I'm gonna reduce the fees so you don't have to just pay a ton of money for supervision and stuff. My concern is more that you get the classes done, learn from this, so you don't end up with a felony, you know?
yes, sir.
All right, good luck, sir. Please. Ms. Barrett, you're charged with assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer spoke with the complainant at Spring High School in Harris County, Texas, and the officer retrieved a video footage of the event. The video showed the defendant turn to the camera, stating ready, and then began striking the complainant multiple times with a closed fist to her head and face as the complainant falls to the ground. The complainant stated she felt pain and showed multiple signs of redness on her face.
Okay, it's in the actual high school, huh?
Yes, Judge.
Okay. Ms. Barrett, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person. Do you understand?
That was, I don't.
I want you to listen because these are your bond conditions. If you violate these conditions, I'm going to put you in jail. I'm also ordering you not to be in possession of weapons as well. Do you understand? Do you have a lawyer today? Would you like me to appoint you a lawyer? Okay. Can you file those conditions, please, Alex? Okay. So what I need you to do, ma'am, is, are you 17, 18? You're 20? Are you actually in high school?
High school?
Are you, you don't go to this high school, right?
So I have.
Stop. I'm only asking you. Then you're not to go back to this high school. Do you understand? All right, so I need you to fill out an application for me. Deputy's going to give you an application, and then I'll have you talk to a lawyer here momentarily. Do not leave until you sign our bond conditions, all right? Oh, please. I don't care where you live. I don't care what you do. You are still under bond condition of this court. If you do not have a Texas driver license, and if you do not have liability insurance, you are not allowed to drive. Do you understand?
I haven't driven.
I am also ordering you not to consume alcohol or illegal drugs. If you get called upon to take a test, you must go to a Quest Diagnostics in Dallas, take a test there, and get the result to your lawyer. It is on you to do that. Typically, when we have someone that does it here, they come into here to downtown and they take a test and I pay for it. But because you're over there, I cannot pay for it. You will be required to foot the bill on that. If you fail to go test when you're called upon, I will issue a warrant for your arrest. There are no more PR bonds. You pick up a new case, you violate any of these conditions. Do you understand? One more thing. I don't know what your immigration status is, but if you go to jail and you're not in this country with permission and you spend any more than 46 hours in custody, you will probably get an immigration detainer and it's not going to go well. So if you're not in this country with permission, you better live like you have a halo over your head. You understand? All right. Good luck. Thanks.
And the next one, Your Honor, is sir.
Just take a
He's also just asking that if he can change the location of his UAs. And I wonder if I could just speak to
Where
see a
does he
little about
live?
that. In Pasadena, Judge, it seems like
No.
somewhere in South Houston. He said, okay.
Still under bond condition of this court, still required. If some time passes and then he's good, then we can perhaps modify. But this is the beginning of the case. I want to make sure that he's not using it.
Yes.
I don't know him. I've never met him. And so, right, I'm just doing everything that I would do to every single other person. Yeah. You are charged with engaging in organized criminal activity. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, The officer was dispatched to a residence in Harris County, Texas. And the call notes from dispatch state the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male. And the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes, Judge.
I don't even know where to start.
My concern is, if you may, I want to bring some, I guess, some points of argument to the court's attention. The first one, my concern is that, I mean, the 911 caller mentioned unknown parties, and then the police officer later mentions them as suspects without any type of articulable facts, believe that they are the specific people or the individuals that have taken this U-Haul. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the things, at least under the four corners of the things, allege that my client was involved with this alleged theft.
I mean, remember, like, so when they start an investigation, sometimes they just don't have everything, and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul.
Yes, Judge.
And they've given a description of a tall, lanky person, right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Cerda remained in the U-Haul. There's no further information regarding Cerda.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality? Like,
and Your Honor,
can you just, does mere presence impute criminality?
Judge, and that's exactly right. Texas law says that mere presence is not enough to bring trouble.
I'm with you.
Oh, yes, sir.
But so
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have the information. We'd have to await the OR, and we don't have at this time.
But I'm not going to sit here and hold
Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because, a person commits an offense if with intent to establish, maintain, or participate in any combination or in the profits of a combination or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as it's pled, is that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS, but right now, Chief is looking at it.
And Your Honor, if we could just maybe reset it for a week or so, we call the witness.
He's in custody, and I can't, I mean, if he was on bond, that would be one thing, but he's in custody. I'm not going to hold him just because, and the compounding it, Casey, is that he's got an ICE hold, so I can't give him a PR bond,
I just need a little more time, Your Honor, to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, by all means, but all right, Mr. Sird, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serta, be careful who you hang out with, Okay. All right, for sure. Good morning, Mr. Ortega. So you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 81 days in jail credit for the 81 days that you've done. You need to understand that this will reflect now as a conviction on your record. It's going to be there for the rest of your life. From now on, any new misdemeanors that you pick up, you will be facing a minimum of 30 days in jail. You understand?
Yes, sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal once you accept this agreement. You can never change this or undo this. Is this what you want to do?
Yes, sir.
How do you plead to the offense, sir? Guilty or not guilty? How do you plead to the offense? Guilty or not guilty?
Oh, I already know.
I'll find you guilty. I see that you got a probation upstairs. Let me say that you're very lucky that you got one with the type of cases that you have. Felony probation is no joke, so don't take it as a joke. You're young, you're still held to a high standard, and you're expected to complete everything you don't. If you go on, you use drugs, you pick up a new case, you could be very well spending a lot of time in prison. You've been given a chance. Make the most of it. You understand? All right. You ever need any help? All you got to do is come back here. Anything you need, cell phones, tablets, food, jobs, we can give you anything that you need. All you got to do is come back and ask. All right?
Yes, sir.
All right, man. Good luck.
Thank you, Judge.
Thanks. Mr. Lockridge, charged with possession of marijuana, you're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 6 days in jail with credit for the 2 days that you've done. Is this what you want to do, sir? They've offered
That's what you
you,
want to do. 6 days credit for 2 times, sir. Yes. Yes, sir.
Yes, sir.
understand that this is going to go on your record. It's going to be there for the rest of your life. You need to understand that from now on, you're facing at least a minimum of 30 days in jail for any new cases that you pick up. Do you understand? You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. How do you plead to the offense, sir? Guilty or not guilty? I'll find you guilty. I'm going to send you to the agreement. I'll roll your court costs so you won't owe anything. Good luck to you, sir.
Thank you, Your Honor.
Thank you, Mr. D. Shh. Mr. Gomez, you are charged with driving while intoxicated. First offense. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. I'm sorry, state. I forgot to grab you. My fault. I forgot to grab you.
Quiet with the interpreter, please.
You have been offered 15 days in jail with credit for the 5 days that you've done. You need to understand that this will reflect as a conviction on your record today and forever. From now on, any new cases that you pick up here, you will be facing a minimum of 90 days in jail. Are we going forward with the enhancement on the 15 or not?
It's gonna be a bad.
Are you sure?
Oh, I'm sorry. Yes, it's not true.
Right. Is it true or untrue that you had a 0.15 or above, Mr. Gomez?
It's true.
Is it true to the enhancement? So understand, that's what makes it a Class A misdemeanor. So from now on, because this is going on your record, if you ever get charged with a future one, you'll be looking at a minimum of 90 days in jail. You give up a lot of rights by entering into this agreement and this plea bargain agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you can never change this or undo this. Is this what you want to do?
Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'll find you guilty, sentence you to the agreement I am going to suspend your driver license or the ability to drive for 90 days. Do not drive until you get a license, and good luck to you, sir.
Maybe
You spent. Hi.
Hey, good morning, Judge. I got two new cases this morning. The first one,
Wonderful.
Barrett.
Okay.
She's in the box. I didn't have the conditions on her. It's an older case.
It is. And so what I was going to do is give you guys a setting, okay? Like a normal 30-day setting, but at that time, she's got to come back here. She needs to make addition on what she's got to do.
Okay.
Case is 250 days old, so I'll give her one setting. Come up. Ms. Barrett, come up. No. I'm thinking of someone. This case isn't that
It
old.
was a 2B. It's like 4 years old, 2B.
Okay. I was thinking of another case. Okay, Ms. Barrett, so we'll just give you normal, just setting.